Hi, I'm John Darrer, and today I'm going to be talking about investing in structured settlements, a guide for the unwary. Let's kick this off with a few important caveats for structured settlement investors. Investors seeking stable income may hear a sales pitch from investment advisors to invest in structured settlements. But all is not what it seems. To be clear, I'm not speaking about structured settlements being used as part of resolving litigation. I'm speaking about investments in another person's already established structured settlement payments post-settlement. This type of structured settlement investment is not without risk and may neither be appropriate nor suitable for vulnerable retirees and personal injury victims. Here are some things to consider. When it comes to the term structured settlement, acquiring other people's structured settlement payment rights in a structured settlement factoring transaction or in a subsequent assignment is not a settlement. Therefore, it is not a structured settlement either. Consumer confusion is not helped by marketing materials, paid ads on Google, and websites of secondary and tertiary market merchants. 2, structured settlement investments are not annuities. Some structured settlement investment promoters and intermediaries solicit investors with the blatant lie that factored structured settlement payment streams are annuities. Unfortunately, the perpetrators of the lie may include certain settlement planners who have given money to trial lawyer associations. A February 2019 presentation at the annual meeting of the Society of Settlement Planners was ominously titled, "Dealing with the Secondary Annuity Purchase That Has Gone South." In its statutory issue paper 160, finalized April 2019, the National Association of Insurance Commissioners, which happens to know a little something about annuities, expressly opined that acquired structured settlement payment rights, i.e. factored structured settlement payment streams, are neither annuities nor insurance products. Please contact me if you need the reference. So a secondary market annuity is not an annuity, period, full stop, and end of report. However, that does not stop players in the secondary market from falsely calling them annuities. One California settlement planner, who held and still holds an active California insurance license, made a declaration under penalty of perjury to a California court in 2012 as part of an elaborate effort to convince a California Superior Court judge to approve such investments to feed into a special needs trust for a disabled plaintiff using a qualified settlement fund. The misuse of the term annuity occurred over and over in the settlement planner's declaration. The declaration ostensibly was designed to gin up the judge by falsely stating there was no change in funding asset. Was it creative? Hell yeah. Was it false? Absolutely. The California settlement planner's declaration was found on the internet in 2012. One wonders how many times a similar declaration was used in the interim with the same or other judges, and how many transactions were approved for disabled plaintiffs or minors under the false assumption annuity was the investment when it was not. Number 3, litigation over structured settlement payment rights demonstrates that investor money can be threatened or completely lost. Litigation is already concluded in which investors in structured settlement payment rights lost their entire investment due to a fraud. Robert and Linda Wall, for example, invested retirement funds and purchased structured settlement payment rights under the advice of their Pittsburgh-based financial advisor, who when deposed stated that the Walls invested in 5 structured settlement annuities. And an intermediary, Altium Group LLC, was sued by the Walls, they actually advertised, invest in secondary market annuities up to 8% returns with no volatility and unparalleled safety of principal. The representations that they were structured settlement annuities were lies. It was impossible. They were not annuities. The Walls were not sold, and the Walls did not invest in annuities even though they thought they did. Then, unfortunately, disaster struck sometime later when a fraud was discovered in the origination of the factoring transaction. The Walls sued their financial advisor and the intermediary who did the deal. In the end, they lost everything. They lost their investment, the bargain for investment return, the legal fees they had to spend for themselves, and to add insult to injury, they had to pay the legal fees of their adversary under the loser pays clause in their contract. Now, the case is Robert Wall and Linda Wall versus Altium Group LLC. It was pending in Western Pennsylvania District Court, action number 16-1044. The next case involves a retiree from Jacksonville who had the majority of his thrift savings plan invested in what was labeled a secondary market annuity. It was later discovered that the acquired payments were originated from the victims of the excess funding scandal in Baltimore, and the investment payments ended up being suspended pending the outcome of litigation brought by the Maryland Attorney General. The heartbroken retiree filed a FINRA claim against the financial advisor and one of its former employees and was able to get a small settlement after considerable heartache. Next, in what is currently known as the Barber case, a California financial advisor and a British company each invested money in factored structured settlement payment streams that turned out to be originated from a structured settlement of a Pennsylvania minor who is only 10 years old when it has been alleged that a pair of structured settlement factoring companies began to bamboozle a number of Butler and Beaver County judges over 8 years. Litigation in Allegheny County, Pennsylvania has the investor's money in jeopardy and is a good example of the risk associated with such investments. Lastly, in Maricopa County, litigation pleading that was submitted in June 2021, Genix Capital Corporation was helpful in stating that one component of its business involves purchasing from payees future structured settlement payments due under structured settlement annuities and assigning to investors a subset of those rights, subset being the operative word. Genix investors found their investments at risk after they attempted to sell and reassign the assigned payments to other investors some years later. Genix Capital objected on the basis that such assignments allegedly violated the terms of the receivable purchase agreement, repossessed the assigned payments, and assigned them to new investors for consideration. A flurry of litigations followed and was pending at the time this video was published. Here are some important points of caution for investors in structured settlement payment rights. Number one, when you buy a legitimate annuity, you're buying an actual annuity contract, which is an actual insurance product. An annuity is defined under state insurance law. Two, when a structured settlement is established as part of the consideration paid for the settlement of all claims against the defendant, a legitimate annuity, that is an insurance product, is purchased to fund the obligation of the defendant, its insurer, or in the event of a qualified assignment, the qualified assignment company. Then a premium is paid to the life insurance company that issues the annuity contract. Number three, an insurance product can only be sold by appropriately licensed and appointed insurance agents and brokers in accordance with the laws of various states. There is no equivalent licensing standard for structured settlement factoring industry or the tertiary market which participates in making such investments available to investors. Four, when the originating structured settlement factoring company buys structured settlement payments in a structured settlement factoring transaction, they're not actually buying an annuity or an insurance product. Five, unless the investor is a direct designated assignee in the court order approving the structured settlement transfer, the investor is buying a subset of rights to certain payments. Six, ownership of the actual annuity that is generating the payments is not transferred to the originating structured settlement factoring company. Since the originating structured settlement factoring company is not buying an annuity or an insurance product, just the rights to the payment, it follows that a subset of those payment rights, as Genix Capital eloquently refers to what investors are actually buying in exchange for their investment, is not an annuity or an insurance product. Number eight, investors in structured settlement payment rights, number one, may lack statutory protections in the event of insolvency. Two, they are exposed to transactional risks not present in the purchase of legitimate annuities that are insurance products. Nine, these risks contribute to why investments in structured settlement payment rights may be unsuitable to many investors, including minors, disabled persons, and retirees. Well, I hope you found this information and caveats to be useful. Of course, you should take your time to be sure you completely understand this investment opportunity, the risk and potential rewards, and determine if this type of investment is suitable for you, your client, or your ward. If you have any questions or you'd like to engage my services, please contact me at the number below. Again, I'm John Darrer. Thank you for watching, and have a great day.